My initial view in terms of the president's expression of disappointment with the CJ's communication, which was found in the public domain, I think that the initial error came from the president. Samson, we are talking about the impeachment of the Chief Justice. It's not a mean matter. It is different from the removal of the head of an independent constitutional body. That distinction ought to be made clear. We have three arms of government: the judiciary, the legislature, and the executive. If you want to remove the Speaker of Parliament, it's such a grievous matter. It's a very weighty matter. As opposed to if you want to remove, for instance, the chairman of a committee of Parliament. They are two different things. If you want to remove the Speaker of, if you want to remove the Chief Justice, that is the head of another arm of government, is so significant that that person cannot hear the news just like all of us do in the media. With the greatest of respect, even if the Constitution has said, which we all admit, that it should be an in-camera hearing, nothing stops you from informing the Chief Justice that I've received a petition and I'm taking the following steps, right? But for the Chief Justice to hear, just like we all did in the media, I think that the presidency erred. And in terms of disappointment, I think that the greater portion should be placed at the doorstep of the presidency. It shouldn't have been so. And that also doesn't make the Chief Justice's, the putting of the Chief Justice's correspondence in the media right. But I cannot say for sure.
Or copying those who should not have been copied as being alleged.
I cannot say for sure that it was the Chief Justice that put it in the public domain. And so I can't condemn her. But what is certain in this matter is that the president failed to communicate the reception of the petition with the Chief Justice. I think that was wrong. We should not be rushing to the media, right, in affairs of state of this nature. The impeachment of the Chief Justice is a very serious matter. In
your interview I'm talking about, it was suggested to you that if it's been forwarded to the Council of State, then they are going to make the prima facie without the input from the Chief Justice. And you said, no, that was presumptuous. That was too early and premature to suggest.
You see, I think, I've had a very careful reflection of this matter. Firstly, we all need to acknowledge the fact that as we sit here, the position of the law respecting Article 146 continues to evolve. Even after Ejechum, the Supreme Court acknowledged in the case of Derry versus Attorney General that, and let me read, that the question is this: if Article 146(8) of the Constitution is violated in terms of public disclosure of the content of a petition, does it render the original process, being a petition to the president, null, void, and of no effect? This question has been posed because in the case of Ghana Bar Association versus Attorney General, right, and another, hereafter called the GBA case, as well as in the case of Ejechum versus Attorney General, hereafter called the Ejechum case, this question was not addressed and answered, even though this constitutional provision featured in both cases. And so the whole gamut of Article 146 seems to be evolving. And so that's the position initially I took. But upon a careful reflection and what we are dealing with, some said, I don't think we are dealing with a light matter at all. People I've heard, like I said, are comparing this to the removal of Madame Charlotte Osei and so on. They are distinct. They are distinct. It is not for nothing.
They are talking only about the procedure.
The procedure. It is not for nothing that when it comes to the removal of the president, the Constitution calls it an impeachment of the president, and the procedure involves Parliament. It is not for nothing that when it comes to the impeachment of the Speaker, there's a gamut of procedure, and it is a very weighty procedure. And so, very respectfully, even in our interpretation of prima facie, we should begin to look at it in that light. And so, when you look at the Black's Law Dictionary of what constitutes prima facie, yes, it is looking at the document on its facie, its face. In fact, the definition of prima facie by itself, I mean, it speaks for itself. That on the face of it, on the face of what? On the face of what has been presented to you, when you look at it, it should tell you whether there is a case to be answered or not. And that is why the police determines a prima facie just by a complaint, not necessarily by, looking at the statement of the accused person, right? In some other instances, for instance, employee relationship, prima facie goes beyond just what the complaint is, because you are sent a query, your comments are invited, and then you give your comments. And then based on that, they determine whether to proceed against you or not to proceed against you. So we need to look at the context. And having taken a look at the context, I think that something, as I said, the gamut of law in that area continues to evolve. I think that on the basis of Articles 1, 4, 6, 10, and 8 alone, the comments of the Chief Justice is necessary. On the basis of Article 1, 4, 6, and 10 alone.
Aikoto was mentioning that.
Yes. You see, when you look at Article 1, 4, 6, 8, the whole proceedings is supposed to be in camera. And so it has come to our attention that there is a pending petition that is being looked at, right, inquired into in the case of the Chief Justice, right? But we don't know. It's supposed to be in camera. But at the same time, under Article 14610, the President has the power, on the advice of the Council of State, to suspend the Chief Justice. That in itself,
ending the investigation after a prima facie has been made.
After the prima facie has been made.
Yeah.
What does it mean? The Chief Justice has been suspended. We are here. The Chief Justice has been suspended. The Chief Justice's comments were not received. Then she has been suspended. No. It is a very serious matter.
From that point, do you think this process should continue to be in camera? It should be in closed doors?
No, I think it has to be in camera.
It has to?
Yes, it has to be in camera, because you may, as the Chief Justice or a Justice of the Superior Court, may as well be found not to have committed any wrong, right? But if you are not careful, you'd have soiled the person's reputation.
So a lot of exceptions. When it's about this Chief Justice, we shouldn't look at prima facie the way it is. We should find, a certain elevation for it, as you have said. When it's about an ordinary citizen, or when it's about independent of office holders of independent constitutional bodies, it's a lesser one. So you are not really bothered about that. When it's about ordinary persons, it's okay to proceed against them without hearing from them first to determine prima facie.
You see, when it is about an ordinary person, he's not an office holder.
That's right.
When it is about an ordinary person, you are dealing with him in terms of the wrong that he has committed. When it is about an office holder, right, there are two levels. The fact that the person is removed from office doesn't preclude punitive sanctions, right, by way of criminal proceedings or civil proceedings. So there are distinct levels.
Unlike the criminal proceeding where everybody has a right to go and sit in the court and watch and follow.
You see, even in civil litigation, we do say that the burden, the standard of proof, right, is what?
Preponderance of probabilities.
But when an allegation is made against a dead person, the degree is higher. The degree of burden is higher. And so you would appreciate that in law, based on the circumstance, different scenarios play out.
Right.
And that is why in this instance, we have to be very careful. Because it cannot be that an impeachment proceedings against the Chief Justice that potentially may lead to his or her suspension before the hearing actually even commences, and then the final sanctions are imposed, right? Her comments will not be received prior to
So the
suspension.
Chief Justice herself,
Yes.
when it is about other people and the petition goes to the president and they take it to her, she insists that you must bring your comments before she will do the prima facie.
Yes.
There's actually been an occasion
The OSP case.
where a petition was forwarded to her.
Yes.
And she said, bring your comment before I make my prima facie. And the other person said, my understanding of prima facie is that it's your job. I don't need to bring my comments. And she said, bring your comments. If you don't bring your comments, then perhaps I'll just go ahead and say, prima facie is, and then you are in trouble, you know?
Yeah.
So do you stand the same place where your colleagues stand? That the suits, the two suits at least, by Ebenezer and Vincent Assefuah, and the injunction application, all of them have become otiose, moots?
The injunction may, but not the substantive matter. You see, this discussion presupposes a fluid area. And so it's an evolving matter. It has happened for the purposes of future, for the avoidance of similar or possible mistakes in the future, right? In terms of how we deal with matters of this nature, right? The Supreme Court will still proceed.
But I thought I have heard over and again that the Supreme Court has already pronounced on this. So there's no
The
need.
Supreme Court has not pronounced on the procedure in terms of what amounts to prima facie.
Whether you should bring a response or not.
Exactly. It's not been determined.
You disagree with those who say it's been determined?
No, it hasn't.
Okay.
Because you see, when you look at the obiter, right, that is the comments made by for the purposes of your readers, by the side or by the way, in the case of Derry versus the Attorney General, right, suggests to you that there is even it's not a settled area, okay? And how they even evaluated the prima facie confirms my position that indeed, because it's a quasi-judicial function, a decision, a comment must be invited. That procedure has not been resolved. It's something. You see,
but the suit is not in a vacuum. So if you say the suit remains, the suit is mounted on the basis